median loss, which is $954,000. What's the point here actually, and what's these key findings are that all these this median loss basically is around owners and executives. They are committing only 20% of occupational fraud, but the largest losses causing to the company. You can see that median loss from owners and executives is $600,000, and then managers $150,000 and employees $60,000. So keeping this in mind, we'll see the case of Enron. We know that when Sarbanes-Oxley Act came, there was the basic reason behind that was several financial scandals. WorldCom, Enron, Tyco, many others at that time were coming, and it was a serious need to have some legislation which can control what is happening, can have some better uh, suggestions about how law should manage these things. If we just go see some points from Enron case, because Enron was incorporated in 1985. It was an energy company, was a major electricity, natural gas, and communications company. Was based in Texas. Um, the main it was founded by Kenneth Lee, or Canley, and they employed 29,000 staff. That will show you how big this corporation was. It grew to $60 billion in 10 years period, uh, which is humongous actually. What has happened? Uh, they have cooked the books. There was some shady accounting practices they adopted. Uh, the Canley was made responsible after the court proceedings. Jeff Skilling, who was the CEO, and he resigned around 2001, just before the bankruptcy filing happened, and then Canley was the CEO at that time. But Canley was handed a huge imprisonment of 45 years, and then Jeff Skilling for 24 years. He's back to business, by the way, last year. He served his prison term already. Mm. And there was CFO. He also was given some penalties after this. There's a very good movie on this. You can go and check Smartest Guy in the Room. You will definitely enjoy it. So, so when we were talking about the shady accounting practices, what they did, they were recognizing revenue. They started this term of M2M, mark to market. So what they were doing, they were recognizing revenue when it was not actually eligible to be recognized. In case of, they had a deal with Blockbuster for 20 years contract. Even though the technology didn't work, terms were never clear. They recognized for revenue for 10 years, which was again questioned by even some of the key management team. But again, this has happened. They pushed their debts to the subsidiaries, which was again uh, questioned. But again, it was all hidden until unless things started opening up. Arthur and Anderson was blamed for that. They had in between a California deal. It's more political involvement in that, but they got a merger with one company in California, Pacific Gas and Electric Company, and they had the access to Californian grid. So they actually created artificial shortage, to get the benefit. And this is there are so many other deeds actually and failed projects they had. But the main thing was the disclosures were not transparent out of these deals. The accounting practices were not uh, uh, as they should have been. They got bankrupt in 2001, and we all know actually. I mean, most of us study what has happened in Enron, and there's so many details in that. This is what we know, publicly available data. So let's understand, keep all these things in mind about Sarbanes-Oxley, about Enron, and then when we'll jump to the Sarbanes-Oxley, that will help us in understanding what was the impact of SOX Act. Basically, this act amended Securities Exchange Act 1934 and Securities Act 1933. Also, there were some amendments to this act by subsequent acts, which is Dodd-Frank and Jobs Act. What was the main purpose behind? The main purpose behind Sarbanes-Oxley was to tighten the regulation of public accounting firms issuing audit reports, and to make principal signing officers more accountable. Even though this was the key objectives around the whole exercise, but there were so many really good clauses, good controls they have implemented in between, which we need to see, and we'll see in the upcoming slides. So what are the key components of the act? First was public company accounting oversight, a very good actually legislation to implement some control over the public accounting firms who are auditing the issuers. The auditor independence clauses, again, very interesting part. We'll see that corporate responsibility, enhanced financial disclosures, conflict of interest, commission resources and authority, studies and reports, corporate and criminal fraud accountability, white collar crime penalty, again an important deterrent for the whole corporate world, corporate tax returns, and corporate fraud and accounting. What was the need and basic purpose? Now, taking the lesson from what we have just seen in the case of Enron, and you are aware of other financial scandals happened, they have shaken the trust of investors. Number one. Then there was lack of corporate responsibility and accountability on executives. Ineffective and or incomplete disclosures, lack of or absence of investors' right. We can see that investors lost billions and billions of dollars in those scandals. There was not a very robust mechanism to oversee accounting. So these were the issues actually when Sarbanes-Oxley actually addressed. They enhanced the investors' confidence. They tightened the regulations of accounting firms, established corporate responsibility for financial reports, enhanced the audit committee role, enhanced financial disclosures, and penal actions on violations. So let's talk about auditors' independence, a very interesting area. So what Sarbanes-Oxley, in fact, highlighted that there are some out of the scope practices by the auditors that affects their independence, that affects how objective they are. Because when they are getting more assignments from the issuer, they are actually they may incline towards management more about giving their opinions. They have to be transparent when they are giving their opinion. So Sarbanes-Oxley Act actually highlighted the non-audit services, which were any professional services provided to an issuer by a registered public accounting firm. Let me just see if Izhar, you are there? Need to unmute. So any professional services provided to an issuer by a registered public accounting firm, other than those provided to an issuer in connection with an audit or a review. of the financial statements of it. So what Sarbanes-Oxley did actually, they identified some non-audited, yeah, or we can say that these out of the scope services, which includes like bookkeeping, financial information system, design and implementation, appraisal or valuation services, actuarial services were part of it, uh, outsourcing of internal audit, management functions like HR or other management functions, broker or dealer, investment, legal services, and any other in-permissible activity which is actually given by the Public Company Accounting Oversight Board. Uh, so now what Sarbanes-Oxley did, they amended the relevant section of Securities Exchange Act, and they added these prohibited activities. What was the general rule here? General rule was that all audit and non-audit services to be approved by auditor. This was the general rule. So whether these are audit services or non-audit services, audit committee has to approve. Uh, Again, it includes tax, which is not in the prohibited services, but tax is also needs approval from the audit committee. So this is how the control was and more authority was given to the audit committee to control what services are being provided by the audit, which is again a very good uh, change in the rule and the pre-approval requirement of the audit partner rotation. Again, it was unlawful. I mean, like for a public company, public accounting firm to provide audit service to an issuer. So if the lead audit partner, like in case if the lead partner has performed audit for the issuer in each of the 5 previous fiscal years. So I'll repeat this point that if an audit partner has performed audit for the last 5 fiscal years, then he is not allowed to do an audit likely. It's not lawful for the public accounting firm to provide audit services to an issuer. So there's a limit of 5 years they have put by using the Sarbanes-Oxley Act. Also, some other clauses were introduced around conflict of interest and enhanced audit reporting, audit reporting to audit committee. Conflict of interest was like if the CEO or controller or CFO or any chief accounting officer or the person who is actually managing these roles, they have been serving in an equivalent position for the issuer, and they are employed by that registered public accounting firm. So then they cannot do the audit for 1 year at least. For audit reporting, enhanced reporting to the audit committee. Again, all critical accounting practices, policies, discussions between the auditor, discussions between the auditor and the management, all these and alternative treatments, all these are required to be communicated to the audit committee, again for uh, uh, full disclosure and giving them ability to take decision that how transparent the audit has been. So these are the relevant to the key points in auditors independence, which is again uh, enhance the overall control from audit committee and also given more independence to auditor, because they were not looking for other businesses in this scenario. Public Company Accounting Oversight Board, a very important change by Sarbanes-Oxley. They have actually established this board. What was the key reason? The key reason was to protect the interests of investors and public. How? By preparing information which is accurate and independent. So the audit report they were controlling by implementing the more regulations from the board, from Public Company Accounting Oversight Board, and they were tightening the regulations on the public company accounting firms who were issuing the audit reports. Yeah, and to start with, the first requirement was that any auditor or any accounting firm is providing auditing services to these issuers, they need to register with the board under this law. Also, Sarbanes-Oxley provide guideline on how the board should be formed. Like the members, there should be 5 members. They should be prominent of integrity and reputation. They will be demonstrating a commitment to the interest of the investors and public. So an understanding of securities law, financial disclosures, and an understanding of the auditor's obligation. So this was the guideline given by the Act, how board should be composed. What was the key role of uh, the board of a public company accounting board? In fact, they were setting the standards. They were registering the public accounting firms, and they were conducting the investigation, the inspections of the registered public accounting firms. So they were doing inspections and they were doing investigations or disciplinary proceedings. And they were also imposing sanctions on the firms if they finding out anything. Uh, sorry. Okay. And they were also promoting the professional standards and improving the audit quality. So they were working on this was the main responsibility of the board as well, that and also enforcing compliance of the SOX Act. So they were the monitor of this act from their side, sorry. And they have some administrative roles. Corporate responsibility. Again, an important area. So what a very interesting change brought by Sarbanes-Oxley was that they have they have actually the audit committee of the issuer was directly responsible for a lot of, like, they were giving more authorities and powers again to monitor and control the whole process of financial disclosures. Like they were responsible for appointment, compensation, and oversight of the work of any auditor employed by the issuer. And also, Sarbanes-Oxley has also guided on the criteria of these members who the audit committee, who can be the members of audit committee, like should be the board member. So there is a link from the board of directors because it's a subcommittee of board, should be independent. And when we say independent, this is also defined that it means that he or she may not accept any consulting, advisory, or other compensatory fee from the issuer. And it be an affiliate person of the issuer or any subsidiary of it. Uh, Another thing was whistleblowing system, even though it's not exactly the term which you will find in Sarbanes-Oxley, but this is what they have proposed to that the audit committee should establish the procedure for receipt and retention and treatment of complaints, and it should be anonymous, confidential, and employees who are highlighting these should be protected. Also, audit committee was giving more authority on keeping the advisors with them because they cannot be expert of everything. So if they want, they can hire advisors to help them. As we know that there is a financial requirement under section 13A and 15D of Securities Exchange Act. What Sarbanes-Oxley wanted that whatever financial filing requirement is there, the people who are certifying the CEO, CFOs, or any other authority within the issuer, which is certifying these. They will certify, who are signing these, they will certify, in fact, for each annual or quarterly report that the signing officer reviewed the report. There's no untrue statement of the material fact. There's no omission of a material fact, and which makes the statement misleading. And financial statements fairly present in all material aspects. This is what the requirement of certification, again, which make the signing officers more responsible. We can link this back to the Enron case, and we can see that how the CEOs and CFOs, when they are certifying this, they need to have the responsibility of the internal control systems. And actually, this is also highlighted by Sarbanes-Oxley that these signing officers, they are responsible for establishing and maintaining internal controls. They have to design such internal controls to ensure that material information is made known. They have evaluated the effectiveness and all these. So they are giving assurance, and they are not only giving assurance, they are actually taking the responsibility on this. Uh, and there are disclosure requirements also from the signing officers, like all significant deficiencies are there. If there are any frauds, they need to disclose those frauds. If there is any significant deficiency in the design or operation of internal controls, which could adversely affect the issuer's ability to record, process, summarize, and report the financial data, they have to. And say that we have identified this to auditor, and we have discussed this. So all this is again, this is a very important area. Again, in this small 2 hours CPD, we will be giving you a brief idea about, but this law is really an interesting law. It gives a lot of information. It needs really more time to give and provide what type of certification. I mean, I've been involved in with some of the companies for implementation. So I know that it's a long process when uh, uh, the signing officers are giving the certification. There's a full process behind that, which has to be implemented. It takes time. So we will be now talking about the enhanced financial disclosures. This is another important area. But before going to that, I think I have missed one point here or 2 points here for corporate responsibility. This is regarding the improper influence or forfeiture, insider traders, and all this. The important part is like improper influence. So Cyber has categorically highlighted this, that if there is an influence actually, or fraudulently influence, or coerce, or manipulation, any misleading exercise for the auditor to mislead the auditor, that is called an improper influence, and that has to be highlighted, and that is a fraud. Uh, in forfeiture, they have highlighted that for any accounting restatement due to the material non-compliance, the CEO, CFO shall reimburse any bonus, compensation, and profit realized. So directly hitting the personal benefits as well. And there are some laws relevant to the attorneys and blackouts, and these are really in detail. So we will not be going into those details in this uh, small session. Okay. Enhanced financial disclosures. If you allow me, can we take a small break of 5 minutes So that because let my let me little bit relax on this because this is an important area, enhanced financial disclosure. And in 5 minutes, we will be resuming again.